The Supreme Court just heard a gun case that could reshape every single permit law in America. And a ruling is coming by June 2026. If you carry a firearm, this affects you directly. Quick question before we continue. Are you subscribed yet? Because what I'm about to break down could be the most important legal update you hear all year. This information could determine whether your permit means something different 6 months from now. Hit that subscribe button right now, and let's get into it. All right, let's talk about what's actually happening. And I'm going to give you the real information, not the headlines, not the panic, just the facts laid out in plain English. The case is called Wolford versus Lopez. Say that name again, Wolford versus Lopez. Write it down, because this Supreme Court case is one of the biggest Second Amendment fights we have seen in years. And most people, even most gun owners, have no idea it's happening. Here's what just happened. On January 20th, 2026, the United States Supreme Court sat down for 2 full hours and heard arguments in this case. 2 hours. That tells you right there that the justices take this seriously. This is not a minor procedural dispute. This is a fight over whether states can effectively strip your concealed carry permit of its power, even after you've done everything right to earn it. Let me explain where this started, because you need to understand the backstory to understand why this matters. After the Supreme Court's landmark 2022 ruling called New York State Rifle and Pistol Association versus Bruen, the whole landscape of gun rights shifted. In that case, the court struck down New York's system of making people prove they had a special reason to carry a gun. Before Bruen, New York basically said, you have to convince us why you personally need to carry. After Bruen, the court said that's unconstitutional. If you're a law-abiding citizen, you have the right to carry for self-defense. Period. But here's the crazy part. Some states didn't take that ruling lying down. Instead of accepting it, they got creative. States like Hawaii, California, and New York quickly passed new laws that tried to accomplish the same restrictive goal through a different route. And Hawaii in particular went very far with it. Hawaii passed a law that said this: even if you have a valid concealed carry permit, you cannot bring your firearm onto private property that is open to the public unless the property owner specifically puts up a sign saying guns are welcome. Stores, restaurants, parking lots, gas stations, shopping centers, you name it. If the owner hasn't posted a permission sign, you're automatically barred. And if you walk in carrying anyway, that's a criminal violation. Now, I want you to think about this for a second. Imagine you spend months getting your concealed carry permit. You take the safety courses, you pass the background checks, you do everything the law asks. And then you go to your local grocery store and you realize, wait, there's no sign here saying I'm allowed. So now what? You have to walk back to your car, lock up your firearm, and do all of this while Hawaii's law just turned your constitutional right into a game of sign hunting. That is the exact scenario 3 Maui residents with valid permits found themselves in. And along with the Hawaii Firearms Coalition, they took the fight all the way to the Supreme Court of the United States. If you're finding this helpful, here's something even better coming up. In my next video, I break down the 5 words you should never say when a police officer asks if you're carrying. It sounds simple, but it has saved gun owners from serious legal trouble. Subscribe right now so you don't miss that one. Now, the 9th Circuit Court of Appeals, which is the federal appeals court that covers Hawaii and several western states, sided with Hawaii. They said the law was fine. They upheld it. That's why the gun owners took it to the Supreme Court and asked them to step in. And here is the part that should make every gun owner in America pay attention. After those 2 hours of oral argument on January 20th, 2026, virtually all 6 of the court's Republican-appointed justices appeared sympathetic to the gun owners challenging this law. Reports from legal observers at the oral argument described the conservative justices as skeptical of Hawaii's position. They were pressing the state's lawyers hard on whether this kind of law has any historical basis under the Bruen standard. Let me explain the Bruen standard real quick, because this is important. After the 2022 Bruen decision, the Supreme Court told all lower courts that gun laws have to be judged against the history and tradition of firearm regulation in America. In other words, if a gun law doesn't have a solid parallel from the 1700s and 1800s, it is very difficult to defend it constitutionally. And Hawaii was having a hard time at oral argument explaining where in American history there was a tradition of telling permit holders they couldn't carry in everyday public businesses. Here's what most people get wrong about this case. They think it is just a Hawaii problem. It is not. If the Supreme Court rules in favor of the gun owners in Wolford versus Lopez, it won't just strike down Hawaii's law. It will send a direct message to every other state that has a similar setup. California, New Jersey, Maryland, Illinois, and others have all been experimenting with what legal experts call sensitive places restrictions. Those are specific locations where even permit holders aren't allowed to carry. Many of those sensitive place laws have huge overlap with Hawaii's approach. Now this is where it gets really interesting, and I need you to stay with me here. At the same time, all of this is happening at the Supreme Court. There is a bill moving through Congress called the Constitutional Concealed Carry Reciprocity Act. It's House Bill 38, introduced in the 119th Congress. What this bill would do is create a federal rule that says if your concealed carry permit is valid in your home state, it is valid in every other state in the country. Think about what that means. Right now, if you have a Texas permit and you drive through New Jersey, your permit means nothing there. You're in violation of state law the moment you cross that border with your firearm. H.R. 38 would end that. It would essentially make your permit as universal as your driver's license. Now, quick legal note. Everything I'm sharing with you is educational information, not legal advice. Gun laws are complex and they vary by state. Always consult with an attorney who is licensed in your state before making any decisions about carrying a firearm. I'm here to break down the big picture for you so you stay informed. What you do with that information is on you, and a real attorney is the right person to guide your personal situation. Let's keep going, because we're getting to the most critical layer of all of this. Here is a hypothetical example to explain this. Let's say you live in Florida. Florida is a shall-issue state, meaning if you qualify, the state must give you a permit. You go through the process, you get your permit, and you start legally carrying. Now let's say you drive up through Georgia, into North Carolina, and then into Virginia for a weekend trip. Right now you have to check each state's reciprocity laws individually. This is because each state has its own rules about which other state's permits they recognize. If H.R. 38 passes, all of that confusion goes away. Your one permit works everywhere. That is a massive change for the roughly 22 million Americans who hold active concealed carry permits. But wait, there's something even more important than all of that. Hey, 73% of people watching right now are not subscribed. Don't be part of that group. Join the growing community of gun owners who get these legal updates first, before the mainstream news covers it. Click subscribe right now so you're always a step ahead. Here's the bigger picture that nobody is talking about. As of right now, in 2025 and into 2026, 29 states already allow what is called permitless carry, also known as constitutional carry. That means in nearly 30 states, a law-abiding adult who can legally own a gun doesn't need a permit at all to carry it concealed. They just carry. 10 years ago, that number was fewer than 15 states. This movement has doubled, and the direction of the Supreme Court under the Bruen framework is making it harder and harder for the remaining states to justify their requirements. So let's add this all up. You have the Supreme Court in Wolford versus Lopez, expected to rule by late June 2026. This will likely signal that states cannot use creative workarounds to gut the rights of permit holders. You have H.R. 38 in Congress that could nationalize permit reciprocity. And you have 29 states that have already moved to permitless carry. The question isn't whether the permit landscape is changing. The question is how fast. Here's what most gun owners get wrong in moments like this. They assume that because a ruling is pro-gun, everything gets easier automatically. That is not how it works. Here's why. First, even if the Supreme Court strikes down Hawaii's law, states will go right back to their legislatures and write new laws. We saw this after Bruen in 2022. New York wrote a massive new law within weeks that created a long list of sensitive places where carry was banned. That law, known as the Concealed Carry Improvement Act, sparked years of new legal battles. You can expect the same thing to happen after Wolford. Second, even in states where permitless carry is already the law, there are still specific locations that are off limits by law. Schools, courthouses, federal buildings, police stations. Those restrictions don't disappear. And if you carry into one of those places, you can still face serious federal or state criminal charges. Third, just because your permit works in more places doesn't mean the rules around use of force change. You still have to understand your state's self-defense laws. You still have to understand the duty to retreat versus stand your ground rules in your jurisdiction. This is the part that shocked me when I dug into it. The states with the most restrictive gun laws have been planning ahead. Hawaii actually introduced what insiders are calling an anti-Wolford bill in their state legislature in early 2026. They are trying to get ahead of the Supreme Court ruling. They are already writing fallback legislation before the court has even issued its decision. That tells you everything about how confident they are that they are going to lose. This information could literally have an expiration date. The Supreme Court ruling in Wolford is expected by late June 2026. After that, everything changes fast. Subscribe right now because my next video is going to walk you through exactly what to do. I will show you what to check and what to update in your carry routine once that ruling drops. You don't want to miss that one. Let's bring this home. Here's what you need to take away from all of this right now. The Supreme Court case, Wolford versus Lopez, was argued on January 20th, 2026. It is a direct challenge to Hawaii's law that stripped the practical value of concealed carry permits. The law restricted where permit holders could go. The justices signaled strongly at oral argument that they are not buying Hawaii's argument. A ruling is expected by late June 2026. If the gun owners win, it will send shockwaves through every state that has tried similar restrictions. At the same time, H.R. 38, the Constitutional Concealed Carry Reciprocity Act, is working through Congress. It could make your permit valid in all 50 states. And with 29 states already running permitless carry, the concept of requiring a permit is under more pressure than ever. Here's what I want you to do right now. Number one, find out exactly what category your state falls into. Is it constitutional carry already? Is it shall issue? Or is it a restricted may issue state? That one piece of information tells you a lot about how the coming changes will affect you personally. Number two, if you have a permit, check its reciprocity status. Know which states currently honor it and which ones don't. That list could get much longer or change completely if H.R. 38 passes. Number three, bookmark this channel, because when the Wolford ruling drops, I will have a full breakdown within 24 hours. I will explain exactly what it means for you, your permit, and your rights in plain English. Look, I spend hours digging through court filings, oral argument transcripts, and legal journals. I do this so you don't have to read 80 pages of legal documents to understand your rights. If this video helped you understand something that most people are missing, hit that subscribe button and ring the notification bell. That's the deal. You stay informed, you stay protected, you never get blindsided by a law change. Quick disclaimer before you go. This video is for educational and informational purposes only. It is not legal advice and should not be treated as such. Gun laws are highly specific to your state, your jurisdiction, and your individual circumstances. Please consult a licensed attorney in your area before making any decisions about carrying a firearm. Laws can change quickly, and what is accurate today may be updated after new court decisions. Stay safe, stay legal, stay informed. I'll see you in the next one.